Good afternoon, everyone, and thank you for joining us for our webinar today. We're going to give it just a few moments for our attendees to trickle into our virtual meeting space. All right, I see we have a good number of folks already in our space, so we'll go ahead and get started. Good afternoon, everyone. Welcome to our presentation on preparing for employment-based options as a student, presented today by Path to Papers. Our two panelists are Raju and Camille, and they'll do a little overview on what is Path to Papers and how to get connected throughout today's presentation. A few housekeeping items before we get started. Today's presentation is going to be recorded, and a copy of the PowerPoint and the recording will be shared with all of you via the email that you use to register for today's webinar, as well as it'll be available on our YouTube channel at youtube.com/@findyourally. Um, Throughout the presentation, feel free to drop questions using the Q&A chat feature. Just keep in mind that we won't be able to answer any very case-specific questions. If you do drop something like that in the chat, we'll be directing you to a consultation. With that being said, welcome to today's presentation, and I'll turn it over to Raju.
Thanks, Alonzo. Hi, everyone. I'm Raju Patel. I'm with Path to Papers. Path to Papers is an organization based out of Cornell Law School, and we're here basically, we offer free consultations to dreamers, employers, and their attorneys to try to see if there's any employment-based legalization options for anyone who's looking to try to find another way to legalize in the U.S. And I'm a staff attorney with Path's Papers. I've been with them for about a year. Prior to that, I practiced immigration, employment-based immigration law for about 20 years in private practice out of Atlanta, Georgia. I'm based out of Atlanta. So I'm going to pass it to Camille Becker, who's also going to be speaking today. Camille, you want to introduce yourself?
Sure. Hi, everyone. My name's Camille Becker. I'm a solo practitioner based out of Oakland, but I work one day a week for Path to Papers project at Cornell Law School. A very exciting project. Hope you all can connect, or especially those that are in Northern California and who are either have DACA or undocumented. That's mostly the population we're helping. Today, we're going to talk about all student visa options, including those with F visas and J visas, but our project is limited mostly to people who are without status or have DACA who want to learn about how this actually works. So happy to see everyone to participate in this, and I hope it's helpful.
Thanks, Camille. Alonzo, if you'll go to the next slide. So this is just, there's a QR code here for consultation sign up. We'll talk about that a little bit near the end. As Camille mentioned, we are here to, basically offer free consultations so people can look to see what options they might have. And mostly for dreamers, we define dreamers as individuals who enter the U.S. before the age of 18, arrived before 2021, and graduated from a U.S. high school. Next slide. Okay, so just a little bit about us. The organization started in 2024, and since then we've done over 1,600 intakes and have found that almost over 80% of people we've spoken to are eligible for some type of employment-based option. And that includes green cards, temporary work visas, which we'll be talking about later. And about 25% of them, over 400, are either in process or have already obtained some sort of legalization, which is great. And we're going to go through a lot of things today. We're going to talk about temporary work visas and green cards. There'll be a lot of information. We're going to focus a lot about what you can do while you're in school to maybe make yourself more eligible for these types of visas. So, bear with us as we try to get through a lot of information. Next slide. So we just want to talk. We have a lot of people. It's a tough time out there right now, but we just wanted to give some of our success stories. Luz basically was, took a while for her to get her employer to sponsor her. But once she decided to move forward, they agreed to do it, and she was able to get an H-1B out of Tijuana in April 2025. And she, you could see her quote. I'm going to kind of read it out loud. "I know it feels difficult to even consider doing something like this under the current administration. The fear and risk of deportation are always there, but I hope that my story gives people hope they can trust themselves to get through it and that their presence is valuable here." So just an example of the kind of people that we're trying to help obtain legalization for, and understanding what you're going through to get there. Next slide, please. One more story, Marisol. She also was able to obtain actually her green card. The green card process does take a few years. Again, we'll talk about that later, but she started it a few years ago and was able to get her employer to sponsor her, and was able to get a green card this past April also. And she basically is saying, yeah, it was simpler than she thought it was going to be. And even though it took a lot of years to make it happen, she finally did obtain it. So, all right, next slide. Just a quick note on what is happening with DACA. I know there's a lot of confusion out there. I mean, in general, right now, it is still out there. It still remains status quo. We are waiting on a decision from the judge in Texas, who will be making the final decision on what's going to happen with DACA. The hope is that it will, I guess the thought is that it will continue, and that the hope is that they'll start processing initial applications. The biggest concern is for people who actually live in Texas. I think we're talking to people mostly in California today. So we are hoping for a good outcome, but at this point, it's just kind of remains the way it has been. Next slide. All right, we're going to get into the substance of employment-based work visas. There are two pathways that an employer can sponsor you. There is the temporary work visa, called a non-immigrant work visa, and then there's the permanent green card route. The ultimate goal is always going to be the permanent green card, but some people are going to be required to get a temporary work visa. Some people won't have to get it, but that might be what the employer wants to do. So it really will depend on the facts of your case. But I will let Camille take it over here to talk about non-immigrant work visas.
Great. Thank you. And we can go to the next slide, please. So I want to, mention that some people on this who are watching this webinar might already be in status, like someone might have an F visa or a J1 visa, for example. And then there might be other people who don't have status, and that includes those who have DACA, right? DACA is not status. It's just a temporary protection from removal with work authorization. So for those that don't have status, those that are undocumented, those have DACA, you can't convert to green card based on employment or to a temporary visa based on employment sponsorship through work. So you can't convert from no status to status, in other words, through employment options, right? So when you're considering these options, just keep in mind that the first visa that you get has to be done through the consulates. Okay. And so someone who's undocumented, who has over 1 year of unlawful presence, which we'll discuss in a second, and leaves, triggers a 10-year inadmissibility bar, which requires a waiver. So before we dive into these options, just want to keep it clear that there's sort of two categories of folks, right? Those that are in status that can convert to one of these visa options without leaving, and everybody else who doesn't have status. And you actually can pursue these, but usually have to get a petition approved first, then go abroad to get a visa. And if you need a waiver for that 10-year bar, in particular that unlawful presence bar, then you also have to ask for a waiver at the consulate. So before we dive into these options, I want to keep clear what the procedure is. So the most common visa option is the H-1B visa. The most, historically as an immigration lawyer, we often see students who are in F1 or J1, and they move to H-1B each, but after their student visa is up. So the H-1B requires a bachelor's degree or its equivalent, and the job has to be linked to the degree or equivalent that the employee has. And there's two types of H-1Bs. There's the bottom, which says the very bottom option on this slide, which are the cap exempt options. And those are if you're working directly for a college or a university or certain government or nonprofit entities. They might be exempt from the hundred the the 85,000 per year visa lottery that takes place every March. So those that are cap exempt, if you're working for a university, for example, or a certain nonprofits, you might be able just to have them file an H-1B petition at any time of year without any quotas or maximum numbers of visas that can be given. Alternatively, those that are working for the private sector and who don't work for a cap exempt employer, they have to play a lottery every March. So that first week, second week of March, there's actually a lottery, and they select up to 85,000 visas approximately per year. Next slide, please. So the process for an H-1B is that, once you're selected in the lottery, or if you file a cap exempt petition, you can file at any time. You could get a decision within 15 business days, potentially, if you pay for an extra fee. So it's pretty quick to learn if you get the petition approved or not. Once approved, for those that are, again, without status, you have to go to the petition as a change of status petition, and you activate the H without leaving. If a person has immigration violations, then you would need the D3 waiver. For example, the unlawful presence bar admission. You'd have to go to the consulate and ask for that waiver, which can be approved within a couple of weeks. And then you return with the waiver and the visa in your hands. There's a new $100,000 fee that Trump implemented last year. And unfortunately, that's causing some problems and hiccups. There's three lawsuits challenging it, including one by the state of California that was filed with 20 other states that was filed in Massachusetts. There's another one filed in Northern California by a group of global nurses with unions and other groups. And it's likely that we may see the 100,000 fee go away. But right now, the $100,000 fee is a deterrent for people filing the H-1B lottery. If uh, for this coming year. So it's sort of a new hurdle that hopefully will go away, but it's bees. Next slide, please. So what do you do looking at maybe I'm a student, I'm an undocumented student, I have DACA, I have a student visa, and I want to look at when I graduate, I want to look at an H-1B sponsorship. So what can you do? Well, different fields are more amenable to the H-1B process. STEM fields, for example, science, technology, engineering, math, healthcare, education, business, those often align with a position that requires a degree. Um, you also want to take into consideration that every March is the H-1B lottery. So if you graduate in May, you may want to see if you can play the lottery in March before you graduate. Right? Cap exempt employers can file any time of year, but that's a timing restriction. So if in your last year of studies in particular, and you have a job offer, there's a deadline in March. Keep that in mind. You can seek support from career centers, international student offices, and campus legal clinics to fine tune your skills to make the H-1B process potentially more enticing for an employer. Next slide, please. The next option that we often see is the O visa. The O visa is an extraordinary ability visa in sciences, arts, education, business, or athletics. There's also one for arts. For artists, there's an O1A and an O1B basically. It requires national, international recognition and sustained acclaim. So maybe people that are, young professionals, this may not be an option, but for some people it is. Um, it's usually up for 3 years and then extensions are possible. The next slide. In order to qualify for the O, you have to really build a record of distinction. You have to have some kind of original contribution to your field. Oftentimes that's research. Um, you have to publish, you know, publishing academic or creative work. So especially if you're getting a PhD or a master's and you can get more publications, there's certain things you could do while you're a student to become O eligible upon graduation. Artists, for example, have lots of public works, and they publish their work at different artistic exhibitions, and that can be helpful to get the O. Leadership roles in national organizations can be a factor that can help. and participating in prestigious internships. So if you think you might be eligible for the O, it's good to always consult early and see if there's ways that you can build up your resume to become O visa eligible in the future. It's smart to do that consultation early on. And Path to Papers, for example, if you qualify for a free presentation, consultations can actually help you assess and vet your O, even if you're still in the process of getting a degree, so you can plan ahead. The next slide. Other non-immigrant visas to think about are TN visas for Mexicans and Canadians. Those visas are only certain professions that are listed in what the NAFTA agreement, which are basically things like it's kind of random which professions that qualify. But like if you're Mexican and Canadian and you want to look at a TN, I'll give you an example that an engineer works or a lawyer works, but a salesperson doesn't or a marketing manager doesn't. So there's certain professions that randomly are listed and others that are excluded. So it depends on what your field is. You might be and if you're not Mexican or Canadian, you may be eligible for an easier, faster visa called the TN visa. An L1 visa is for somebody who works 1 year abroad and then they return to a US company that's related to the entity abroad that you worked for. So, you're working for a big company like Facebook or Salesforce, and they send you 1 year abroad to work in the Mexico City office or the Paris office. You could then transfer back to this San Francisco office on the L visa after you've worked 1 year abroad. So you have to go work abroad for 1 year before that's available. The next visa, next slide. So, as I said, for those that are undocumented or who have DACA, you may not think you're eligible to get the visa because when you leave, you may trigger what we call the 3 year or the 10-year unlawful presence bar. So, the rule is you start to accumulate unlawful presence when you turn 18. But that unlawful presence can stop if you had DACA approved, or you have an asylum application filed, or if other things are on file. You may stop the accrual of unlawful presence. Even though you're 26, you may not have unlawful presence. So it's a very case specific analysis. But for those that, for example, were 19 or older when their first DACA was approved, they would have 1 year of unlawful presence, which started when they're 18. For those that are in F visa status or J, you don't have unlawful presence, so you can safely travel abroad. Or for those DACA beneficiaries that were younger, let's say you had your first DACA approved when you were 18 and a half. Well, you may not have any unlawful presence bars. So the the unlawful presence bar basically triggers an obligatory denial when you go apply for your visa. But luckily, next slide, please, there's a waiver, a magic unicorn waiver. So I've heard some people say it's a pretty easy waiver to meet the standard. You just have to show that you kind of like had a one-time mistake, and the mistake is I was brought here as a child for many people, and I've otherwise been a good person, right? And you just show that the reason you're coming back is to support the economy, and that generally speaking, you didn't commit an offense that was so serious that this shouldn't be waived. Um, and so when you get an H-1B or an O visa petition approved, for example, you just simply schedule a visa interview abroad, go to your visa interview, tell the consular officer, I have the bar, a 3 or 10-year bar, and here's my waiver application. Please grant it. There's an expedited waiver application available to those that have a degree from the US and are coming to work for a US employer, and those can get approved today within 2 to 3 weeks sometimes. So it's a little bit of a longer wait than the typical visa processing, but it works, and our organization has helped many DACA beneficiaries, undocumented folks get these H-1Bs or O visa petitions, go abroad, apply for the visa, apply for the waiver, and return in valid status. Once you do that, you now become eligible for the green card options inside the country that Raju's going to talk about. You no longer have to go abroad to apply for the green card. Once you have that lawful admission in H or O status with or without the D3 waiver, you now can apply for the green card inside the country. So this is usually the first step we try to take because it's faster than the green card process, as Raji will speak about in a moment. Okay, the next slide. So for those that are in status, those that have F1 or J1s probably on this call, there's other things you need to know. Um, while you're in school, there's a work authorization called Curricular Practical Training, CPT. As long as it's an integral part of your academic program, you can work and be authorized to work through your school through the SEVIS program. This also includes some day one CPT programs, which allow CPT authorization at the start of the program. So, especially those that are getting masters, sometimes you can work lawfully with CPT even from day one occasionally. Most often for regular bachelor's and associate degree programs, you have to study one full year before you're eligible for CPT, but there are exceptions to that. Now, for those that graduate from a degree issuing program, you get potentially optional practical training, OPT. And post completion OPT allows for 12 months after you graduate from each level. So you can get 12 months from the bachelor's level and 12 months from the master's level, for example. After you complete 12 months of OPT, then you can potentially qualify for another 2-year work permit called STEM OPT for a total of 36 months, but only if you graduate with a STEM degree. A STEM degree is determined by the program that you're in and whether ICE has given the right code to that program. So if you're, early on in your career and you're not in a STEM degree, but you're thinking, oh man, it'd be certainly nice to have a 3-year work permit instead of a 1 year, I could change from art to graphic design and I could be STEM eligible. So some of these analyses are good to know early on because you may be able to pivot slightly to a slightly different degree, so you get a 3-year work permit at the end of your graduation instead of a 1 year. And the last thing there, just H-1B cap gap. So if you're in F1 status and you're graduating in May and your OPT is going to expire in May, but you file the H-1B petition before your OPT expires, you get an automatic extension of your OPT work authorization until the H-1B takes effect on October 1st. So those are some basic principles that are really good for those that are in F and J status to know about early on, so you can plan to get to other status potentially after your studies are complete. The J1s, just to keep an eye out there for this thing called the 2-year home residency requirement. You can't move from 8 to H1B or to L or to green card if you're subject to this 2-year home residency requirement, which applies to some, but not all J1 visa holders. All right, the next slide, please. Pass it back to Raju to explain how the green card process works through employment.
Thanks, Camille. And I think my photo's down right now, but the video should, there it goes. Okay. Next slide. All right. As Camille mentioned, so usually the step after the non-immigrant visa is basically the employment-based green card. How do you qualify for an employment-based green card? As I mentioned, some people would be able to go directly to the green card, but it is because it takes several years. It may not make sense for your particular case. It may not work depending on your status. So a lot of things have to be taken into account to determine. The vast majority of people will get a non-immigrant work visa first. So when we talk about green card, there are 3 different levels of preferences. You may have heard of some of these. So the highest level category for the green card are for people who fall under basically extraordinary ability, they're multinational managers, or they're outstanding professors or researchers. And for those people, we say there's no labor certification needed. And I'll talk about that in a little bit and what that means. The second preference of employment-based categories, the second, highest, is for members, basically people who have advanced degrees or persons of exceptional ability. You might have heard of the national interest waiver, which you can self-sponsor. I didn't mention extraordinary ability. You can also self-sponsor yourself. For the national interest waiver, that also falls under the second preference. Again, most of these are going to require the labor certification, and then the people who fall under national interest can waive that labor certification. And then the final category where most people who graduate college are going to qualify under is the third preference. They can include skilled workers, professionals, people even without degrees, and just a couple of years of experience. And that one, all of them require labor certification. Next slide, please. So talking about the first level category, EB1, the extraordinary ability, a lot of people are interested in that because you don't have to have an employer and you can self-sponsor. The outstanding researchers and professors do require a sponsor, and a lot of those are going to be universities, research companies will do those. But how do you qualify for that? It's going to be similar to what Camille discussed in the O1. You really have to start building your resume early. Advanced degrees are going to be important, not necessarily required, but usually we see those. Some of the common fields are computer science, AI, healthcare. Those are, ones that are, I guess, the obvious a lot of times in terms of the EB1. Research heavy professions, professors and scientists, those are going to be good cases for EB1s, and then definitely artists and athletes, some of those high achieving ones can qualify. But even professionals who work in really well-known high-level companies, business world, they can also qualify. So it's not very specific. There's just some more obvious professions that might more easily meet the requirements. There's a whole list of requirements similar to an O1, and the person has to meet a certain number of them to kind of really make their application strong. Most of these are going to require several years of experience before you're really going to be able to show you meet that level. Some PhD holders who did a lot of research, postdoc positions are going to qualify, especially outstanding researchers who are working in universities. They may not need many years of experience if they've conducted a good bit of research prior to starting full-time work. But the key is to really kind of start building your resume while you're in school. Next slide, please. So then the next question is, do I qualify for a national interest waiver? So that category has been, I guess a lot of people think, in the past, it wasn't used as much. And then there was a time where it was being used a lot. A lot of attorneys were saying, putting a lot of different positions and saying, yes, you can qualify for a national interest. So unfortunately, that has laid into a little bit more scrutiny. So it's important to really talk to a good attorney who does a lot of these, who can really analyze your case to see how you can become eligible or if you are eligible, because that is also can be self-sponsored. Again, most are going to have advanced degrees, although it's not required, but then you would usually need several years of experience, or you have to meet exceptional ability standards. Research-based, high-demand fields, the ones that you hear about in the news a lot, healthcare, cybersecurity, things that are just really important, global health right now that you kind of read about, those are going to be good, I guess, fields that show that, the nation as a whole cares about that stuff. Also, business occupations, they can also work if you can show job creation, economic growth. You can qualify under business also for the national interest waiver. The key is starting for national interest, you need to show that you've been continuing to work in that field and advancing, what you're doing. So anything you're doing during college, during getting your master's, doing research, working in the organizations, nonprofit organizations, all of that, certifications are going to really help show how you're continuing and showing that your interest has been going on for years and that you are going to continue doing that once you get the national interest waiver. Next slide, please. And then the most common, this is where I mentioned the labor certification. So the most common process to get a green card is going to be through the PERM or labor certification process. And those are all going to be under that level 2 and level 3 preferences that I mentioned. So the green card process is normally a 3-step process. Some of those higher level ones are a 2-step process. They don't need this labor certification. But the first step in this is basically filing a PERM with the Department of Labor. The good thing with the PERM, this process, is that it encompasses all types of positions, all types of degrees, people who don't have degrees, nannies qualify, domestic work, there's lots of different fields of people who just have experience, don't have degrees that can qualify for a green card through this route. So it's not like H-1Bs that have to have a specific degree that Camille mentioned. That's not required for some of these, like the lower level labor certification processes. The requirement for the labor certification is that the employer has to show that there is no U.S. worker that is able, willing, qualified, and available for the job. So that sounds really difficult sometimes, and we hear all the time, oh, no, you can't, my position, everybody's applying for it. It's a lot more doable than you might think. So, we've been able to do gas station managers and things that you may not think you could be able to show that no one qualifies for can be done. It just takes an attorney and the employer to work together to strategize and to figure out how to do the advertisement. As you're kind of going through your college degree and figuring out what you want to do, companies that sponsor H-1Bs are very used to doing these labor certifications. So IT companies, universities, hospitals, they're going to be some of the better employers that are more likely to sponsor you for these labor certifications. It is a commitment by the employer. It takes a few years. They do have to pay certain parts of the application. So you want to make sure the employer knows you and is willing to go basically pay that kind of money and put that kind of time commitment into you. So, but again, small companies, 2 or 3 people companies, they can also sponsor these. So there's no requirement. It has to be a large organization. Next slide, please. So this is just kind of a subset of the EB, I guess EB2 or EB3. The key for nurses and physical therapists is the government has already said that both of these occupations are in shortage in the US. And therefore that labor certification where you have to prove there's no US qualified workers is not required because the government's kind of already said that they're in shortage. So people who are going in these fields have a really good route towards a green card with the right employer. Hospitals in rural areas are really good sponsors for these types of green cards. There are staffing agencies out there that can place nurses and maybe physical therapists in places that they know will be willing to sponsor you. And H-1Bs, without going into all the detail, are not usually good options for nurses. Some nurses do qualify, but the general nurses are not going to be able to get an H-1B. And so if you're able to go directly to a green card, then it might work. So again, these are very specific fact patterns that have to be discussed with an attorney to see, as a nurse, can you go and get your green card, but you're not going to be able to get an H-1B. And it really depends on your background and if you have unlawful presence and all of that. So Camille, you have something?
And Raju,
Yeah.
if you don't mind,
Yeah,
I
please.
might just say back to my slide on the H-1B and what can you do if you're studying to be a nurse is getting a bachelor's degree in nursing and finding a job that requires that bachelor's degree. So the one exception to what Raju's saying is you might be able to, if you can, an oncology nurse would maybe need a bachelor's degree where a regular RN may not, right? So, but if you don't have the degree that's required for the oncology nurse position, you can't find yourself a job that would require a degree so you qualify for the H. So just to keep that in mind, if you are in nursing fields, there are some strategies you can take early on to find that rare H for the nurse. Especially for those that are undocumented, it's probably it's the best strategy to eventually get into the green card strategy. So,
Yeah,
but
thanks, Camille. That's perfect. And I just spoke with someone who will be getting an H-1B for an ICU nurse. And so you don't hear them often, but they're definitely possible if you go under those niche nurse type positions and have that degree. And that all kind of comes from the fact that there's kind of this general, you can have an associate's degree and be a nurse. And that's why this H-1B hasn't really caught up with nurses necessarily. But again, it is possible, and it's a really good option for a green card if you can, go that route. Okay, next slide, please. Okay, so just kind of an overview of challenges that you can face on the green card path. This goes back to what Camille mentioned about having to leave the US. So it all depends on what your status is, what you can do in the US. The DACA holders and those who don't have any status are going to be required to leave the US unless they have an H-1B first, if they've already left. So basically, you have to leave at least once if you don't have the status and can't change in the US directly. So there is one exception to that, and that is if you have been in the US for a really long time. It's called 245I without going into the details, but if you've had family members from years ago before 2001 who are here, aunts, uncles who maybe filed for your parents, there was this law passed that could exempt you from having to leave. So it's really important to kind of sometimes dig back into your past, talk to your parents, talk to aunts and uncles, find out if anything was filed. Because although you can't use those specific ones, it could help you and exempt you from having to leave, which is a really big deal. And then again, if you do get the H-1B first, then you can just get the green card in the US. You can file what we call adjustment of status in the US. If you don't get an H-1B first, then you do have to leave the US to get the green card. And then there you go again with when you leave the US, you might trigger that unlawful presence bar. So some DACA holders might not trigger it. They go abroad, they get their interview, and they come back with the green card, similar to how they would do it with the H-1B. But if they do have the unlawful presence, they trigger that bar. And there is a waiver similar to the D3 waiver for non-immigrant visas. This is a little bit more difficult of a waiver. It's called the I-601 waiver. And that one, so that does waive the 10-year bar for the green card. The key is you have to have a qualifying relative. You have to show extreme hardship to either a US citizen or green card holder, spouse, or parent. So you have to have one of those qualifying relatives in order to be eligible for the 601 waiver. And if you don't have one of those qualifying relatives, then there's strategies and discussions with an attorney about what can I do? How can I meet the 10-year bar? Do I have to leave for the full 10 years? Maybe you don't. So those are all things, again, a consultation with us. Camille is an expert on those matters without going into all the details of that in this seminar. But there are ways to do it. So the key is just understanding what you're eligible for, what you need. Do you have to get the H-1B first or some sort of work visa? Do you not need it? For students, F1s, they can maybe do everything in the US without having to leave. So really will depend on the facts of your case. All right. Anything you want to add, Camille, to that?
No, I think you got it.
Okay. Next slide, please. And just a quick overview, how long do these take? That's kind of a tough question. A good thing is H-1Bs, you can, again, do you have to go through the lottery? Do you not need the lottery? But if you get picked and you can do the H-1B, you can get a decision within a few weeks, if everything goes perfectly well. And then the question is, do you have to travel abroad? When is the interview going to take? So the 6 to 8 months that, it could be faster, it could be longer. It really will depend on, when can you get an interview? When are you ready to leave? How long are you going to be abroad? The green card, again, that's a tough one. It's 2 to 3 years. What do you think, Camille? I mean, it can be longer.
It might even be 4 now, but
Yeah,
everything keeps going up, but
right.
it's 2 to 4, I would say now.
No, okay. So yeah, so that first step, if you have to do the labor certification, does take a couple of years pretty much at this point. If you don't need that, it might be faster, but then it also depends what level category. So that's where I talked about first, second, third preference. Depends what country you're from. So all of that is taken into account, kind of how long. So that's why planning while you're in college is great, because these are not quick fixes, but you can start figuring it out at this point. What visa might work for you? If you could skip the H-1B, if you start the green card right now, would that work? Maybe, maybe not. So a lot goes into what these time periods might be for you, but as you can see, they're not that quick normally. Some of the temporary work visas can be, just depending if you have to leave or not.
Yeah, I think it's really like the way I look at it when I have someone, whether you're an F, DACA, or undocumented, the first thing I try to find out is, can I change status inside the country through a temporary visa? And if not, can I travel abroad to do that? And then I go to the green card. analysis as the segue after you get the quicker solution. And I encourage people to kind of focus their analysis first on the temporary visa options. Obviously, the green card can work 2 or 3 years, but it's typically a longer term strategy. You can do both at the same time, by the way. You could start the green card process while you're starting the H. So you don't want to ignore the permanent green card pathway, but you also don't want to put too much focus in that until so until you get your temporary visa status solved is kind of the way I look at it typically.
Great. Thanks, Camille. Next slide, please. So yeah, so we're that's kind of our presentation today. So again, sign up for a free consultation. I explained what Dreamers were, how we define Dreamers for our organization. We do give priority for consultations, and that's only because of our grant funding to people who had or have or had a connection to San Francisco Bay Area, or they have a current connection to LA County. But again, anyone can try to sign up. It may just take a little bit longer to get in, but we will definitely schedule you as our capacity allows. You can find us on our website, this QR code, or pathtopapers.org. And I think that's it. Next slide. I think that might be all. Yeah. So our resources, if we should, we're going to share these slides. These all have links to a lot of the specific resources that we talked about today, but our website itself has lots of other resources specific to, D3 waivers and 601 waivers and pretty much anything that you can think about that might help you figure out what you're eligible for. So please go to our website to look at all those eligible resources that are out there. Next slide. I think that's pretty much it. Yeah. So Alonzo, you want to take it over for Q&As? I think we're done.
All right. Don't see any major Q&A. Any attendee that has questions, either feel free to drop them in the chat or in the Q&A feature, and we'd be able to answer them. Again, we're not able to answer a lot of case-specific questions, and so if you have a question around that, um, please connect with our colleagues here at Path to Papers.
I may just read out this one last question that we answered in the chat, but
Yeah.
it's good for everyone to hear, which is, can a legal entrance with advanced parole assist with any of these processes? And I think this is a big issue for those with DACA in particular who have entered with advanced parole. And the unfortunate answer is not for employment-based visa options. A paroled entry could potentially make someone eligible for an immediate relative family-based petition, which means if you have a US citizen spouse or child 21 or older, that petition can potentially be used to get your green card after you entered with parole. But unfortunately, none of these temporary or permanent employment-based visa options are available if you have just that advanced parole entrance. You have to have a lawful admission with a temporary visa in order to qualify for those usually. There's one exception, which is under Section 245I. But of course, with the law, there's always an exception. But that's the only one way if you're grandfathered under 245I that you could potentially get your green card through employment without leaving.
Thank you. I think that was a great question to kind of answer out loud. Um, I'm not seeing anything else coming in through the chat or the Q&A. We thank you for the great presentation today. It was super informative. I've learned a lot, and hopefully people connect with Path to Papers after this presentation. We did record it. We will share the recording and the PowerPoint presentation probably tomorrow or the next Friday. But you will receive an email coming from us here at the foundation with the recording and the materials that were discussed today. But thank you, Raju. Thank you, Camille. Thank you to Path to Papers for putting this on. We really appreciate it, and we'll be in touch.
Thanks, everyone.
Thanks, everyone.
Bye.